Well, joining us now in the studio is Vincent J. Russo, here again to talk with another episode about In the Legal Know. Vincent's here to address the use of Revocable Living Trusts as part of your estate plan. Vincent, there's a lot to get into. Thank you so much for being with us.
Oh, it's great to be here as always.
So you're so informative and you really break it down for us. So tell everybody first, what is a Revocable Living Trust?
Okay, a Revocable Living Trust. It is a trust agreement. It's a document where you set up a trust, meaning you enter into an agreement to take your assets and transfer them into the trust, and a trustee receives it. You can be the same person. So here you are, and you want to set up a Revocable Living Trust. You sign an agreement that says, I'm setting it up, I'm the trustee, and I'm going to take these assets and put it in the trust, and then I'm going to manage them from there. It avoids probate because you can name who the beneficiaries are when you pass away.
Wow. So what are the benefits of creating a Revocable Living Trust?
All right, and that's probably the most common question I receive from clients when they come in. Should I have a will, or should I have a trust, or both? All right, so there are 5 benefits that I can identify when doing a Revocable Living Trust. The first is avoiding probate. And so that's the key one. That's the primary, which is it allows you to have someone step in when you pass away, take control of your assets with no delay, no additional cost, and then the trustee who steps in can transfer those assets out to the beneficiaries. You avoid a court proceeding. It's called a probate proceeding. And that's a significant benefit. But there are additional benefits that you do get from a Revocable Living Trust. Privacy is an advantage. So a will is filed and it's a public record when there's a probate proceeding. With a trust, there's no filing of the trust. So no one knows what your trust provisions are. So the celebrities pass away, they set up a trust, and you don't know who they left their assets to and in what way. If it was a will, everybody would know. So that may be important to someone, it may not be, but it allows for privacy. Control is another benefit. Control because you're the trustee and you can do whatever you want with those assets in the trust. You can change the trust provisions, you can change the beneficiaries, you can change the investments. There's a lot of flexibility with that trust because it's revocable. So if circumstances change, you can change your trust document. And then the last one is disability planning, and I'm going to downplay that a little. If you lack capacity, then a successor trustee can come in right away and manage your assets, and you've laid out what you want to have happen. So it's more powerful than a durable power of attorney, but that's planning 101 for disability, because an irrevocable trust would be a better vehicle to protect assets if you become disabled.
So we talk about the good things. Are there downsides to creating a revocable?
Yeah, there's always downsides to everything, right? So the first downside is it's going to take time, all right? So you're going to have to invest in doing this. You have to retitle the assets. So if I have a house, ownership is shown by a deed, and now I have to change the name on the deed to the name of the trust. It's going to take some effort. It's also going to cost more money to do that. So that could be considered a downside. But you have to do a benefits cost analysis there. And I think it is beneficial to consider a revocable trust in many situations. Also, the downside is that if you think it protects your assets from creditors, no, it does not. You'd have to do a different type of trust to protect your assets from creditors. So that's kind of a downside, but it's, you're not being hurt by doing this trust, but you're not getting an advantage of protecting assets. Also, there's no tax advantage to doing it this way, in that if you have a will or a revocable living trust, the assets are in your estate, subject to the estate tax laws, and you're not really getting any sort of advantage, but there's no disadvantage, so to speak. And then lastly, and this is really important, there's no guarantee you've avoided probate when you do a revocable living trust, because you have to make sure all the assets get in the trust to avoid probate, or you've named a beneficiary designation on an IRA or a bank account. So you got to make sure every asset is taken care of in terms of avoiding probate.
You know, for people watching, they're like, I don't understand. Do I need a will and a revocable trust? Or what's the difference between a will and a revocable trust? Can you explain that?
Sure. So if you do a revocable living trust, you still want a will. And it's called a pour-over will. It's a simple will that says, if I forgot one of my assets and didn't put it into the trust, then the will have to be probated, but the executor will take the asset and place it into the trust. So the trust is the main vehicle for leaving your assets to beneficiaries.
This is why we love having you on, because you simplify everything so we can all understand it. Tell everybody where they can find more resources and everything.
Sure. I'm happy to say that with our law firm, we have guides that can be very helpful. We have an estate planning guide at vjrussolaw.com/guides.
Perfect. Well, we look forward to the next time you're on so we can learn some more. Vincent, thank you so much for being with us today.
My pleasure.